SwayamPrabha. Digital India. Educated India.
Welcome students. Myself Dr. Amrendra Kumar Ajit, Assistant Professor from Faculty of Law, University of Delhi. In the last lecture we have discussed about the transfer by the ostensible owner. Now in this lecture, that is lecture 10, I am going to discuss about lis pendens, fraudulent transfer and part performance. Okay. These three concepts are very important concept under Transfer of Property Act, okay, and they have their own significance. So, one by one I am going to discuss. So, first of all I will take lis pendens, the concept of lis pendens, and if something is happening, that means transfer is happening in that, then what is the law and related case laws. So, topic what I am going to cover in today lecture is that pending suits, compromise suits, fraudulent transfer and part performance. So, first is about the doctrine of lis pendens. Lis pendens means what? Lis pendens means a very literal meaning, it is that suit is pending before the court. That means suit is under consideration, case is going on, and case is going on with respect to what? Case is going on with respect to immovable property, and which is the subject matter of transfer here. So, this is the case, this is the section or law which talks about if the case is going on in court and in between the defendant is trying to transfer the property. If the defendant is not transferred the property, then this section will not apply. Case will go and it will be decided according to a law. But this 52 will come only in case where there is a transfer during the pendency of suit related to that property which is being transferred. Okay. So, this is based on one maxim that is called at light pedente nihil innovator, which means that nothing new should be introduced in the pending litigation. Okay. That means it is a kind of a public policy. Public policy for what purpose? This section 52 says that the end, that is the end of the suit, that is means the giving justice is the prime consideration of the suit. So, that should not be altered, because if something is going to be transferred in between this suit, then justice will not be done properly, it will hamper. So, in that case it has been said that what is the status quo of the property, that should continue once it has been filed, that means case has been filed, then after there should not be transfer of the property. So, it says that it is the necessity for the final adjudication and on the basis of public policy. So, the court so if 52 is not the doctrine of notice, but expediencies, that is necessity for final adjudication and public policy. Then the meaning of lis pendens. So, it says that the property which is in dispute should not either be sold or otherwise dealt. Not sold or otherwise dealt means, that means there should not be any transfer related to that, there should not be mortgage, there should not be lease, whatever the form of immovable property transfer, that should not happen during the pending of suit. So, during the pendency of suit or proceeding, where a suit or proceeding is pending between two persons with respect to an immovable property, one of these parties sell or otherwise transfer the subject matter of litigation, then the transferee will be bound by the result of the suit or proceeding, whether he had the notice of the suit of proceeding or not. Okay. So, it is very important that notice is immaterial for the transferee. Earlier cases we have seen that notice was important factor, but in this case, in case of lis pendens, notice is completely immaterial, that the transferee, if he is going to purchase that property, whether he is purchasing in good faith or with notice, in both the cases, whether it is gratuitous or in case of this with consideration. So, it is going to become immaterial at this stage. That means, whatever the judgment will come, decree will come, that will be binding on the transferee. He will have to take that property with that judgment or decree. So, in that case, it is very essential that during the proceeding of this code, during the pendency of the suit, there should not be transfer of the property. So, it is based on the public policy. So, doctrine does not rest on any kind of notice, but on necessity, and the neither party to the litigation should alienate the property in dispute. Both are prohibited. Generally, it is done by the defendant, but even the plaintiff has been restricted that plaintiff should also not deal with that property. Okay. So, that is the reasoning behind this. So, the principle on this doctrine has been explained in the leading case, that is Bellamy versus Sabin of 1857. What has been said in this case? Lord Justice Turner observed that it is, as I think, a doctrine common to courts, both law as well as of equity, and rest as I apprehend upon this foundation, that it would plainly be impossible that any action or suit could be brought to a successful termination if alienation pendente light were permitted to prevail. Okay. So, the plaintiff would be liable in every case to be defeated by the defendant alienating before the judgment or decree, and would be driven to commence his proceeding de novo, subject again to be defeated by the same course of proceeding. So, it is very clear, this observation of Justice Lord Justice Turner is very clear, that whenever this defendant is going to transfer the property during the pendency of suit, then what will happen? He will defeat the right of plaintiff. So, plaintiff is not going to take benefit from that, plaintiff right cannot be restituted. So, in that case what will happen, and whenever it will happen, then again there will be same transfer. So, and the new cause of action will arise. So, always there will be increase of number of litigation, as well as it will be against the right of the plaintiff. So, overall if you go to if you see this, then you will found that it is against the law as well as it is against the equity, because equity is also based on this principle of justice, equity and good conscience. So, in that case equity will not serve the purpose. So, in both sense there is kind of a right thing, right procedure, that at least during the pendency of suit there should not be the transfer of litigating this property, the property which is in litigation. Okay. Next is Narendra Bhai, Chhagan Bhai Bharatiya versus Gyan Devi People Cooperative Bank Limited of 2002 Gujarat. What has been said in this case? The Gujarat High Court said that the principles contained in this section are in accordance with the principle of equity, good conscience or justice, because they rest upon the equitable and just foundation. that it will be impossible to bring an action or to suit a successful termination if alienations are permitted to avail. That means, if transfer will be allowed and transfer will remain allowed during the course of this transaction, okay, during the course of this pendency of suit, then this successful termination will be not reached. That means, the dispute will not reach to a proper conclusion and justice cannot be delivered in a proper way. So, this is always a this will be always a kind of threat to justice if this principle will be not there. So, that purpose it is going to be said, this is the principle of equity, principle of justness, because it is so sine qua non for the justice in the case of disputed property, that if it is not going to be transferred, then only justice will be done. Otherwise, the continuous transfer of the property will result into injustice to the plaintiff, and it will be not only injustice to the plaintiff, because the number of suit will increase for every cause of action, then it will be the loss of time and exchequers also. Okay. So, in that way it has been prohibited. Allowing alienation made during the pendency of a suit or an action to defeat the rights of plaintiff will be paying a premium to the cleverness of a defendant and thus defeat the ends of justice and throw away all the principle of equity. Just means, because if you will allow it, then it will be a kind of premium to the cleverness of the this defendant. So, it should be prohibited. Then, in case of Love Rajkumar versus Major Daya Shankar, it is in 1986 Delhi High Court. In this case, what Delhi High Court said? That Delhi High Court held that the principle of 52 applies even where TPA does not apply, because the section is based on justice, equity and good conscience, because it is the principle of equity. So, in certain cases where the TPA provision is not applicable, even in that case it will be, because it is so fundamental in nature that no one can deny it. If you will deny it, then it will not result into the justice. So, for that purpose it has been said that it is so fundamental in nature that in case of non TPA dispute also, where the TPA Transfer of Property Act provisions are not going to apply, it will be applied through the doctrine of equity, because every court has power to do the things for the end of justice, and if the court will see that okay, it is not going to apply through the Transfer of Property Act, then court may use the principle of equity. So, in Muhammad Ali Abdul Chinomin versus Bisha Harry Com Abdullah AIR 1973, Mysore High Court says that the principle of lis pendens embodied in section 52 being a principle of public policy, no question of good faith or bona fide arises. That means, I told you earlier that if the purchaser is purchasing, that means transferee is purchasing with notice with good faith or without notice with good faith, okay, even in that case transferee will be liable. That means, earlier we have seen in previous sections that there was certain restrictions, that some consideration, if there is a consideration and notice, then it will be liable, transferee will be liable. If it is gratuitous, even though it will be liable, but in case of consideration plus good faith, then transferee was not liable. But here that is not the case. In this case, it is a kind of absolute liability on the part of transferee, that if there is pendency of suit related to the property which is going to be purchased by the transferee, then transferee will be absolutely liable there. Okay. In that case, it will work. So, this formula is that transferee, whether it is doing under the good faith or not, it is completely immaterial for this section. What are the essentials? Okay. So, the following condition must be fulfilled for the applicability of this section. What are those? So, there must be the pendency of suit or proceeding from the date of the presentation of plaint or institution of proceeding in a court of competent jurisdiction. Okay. And that is the important case here is Gauri Dutt versus Sukur Muhammad 1948. That means from when it will be presumed that case has been filed. So, certainly from the date of filing of the case. Okay. But in this case what was happened, that the transfer was just done 1 day after of the date of filing. Okay. So, question here was whether this will be treated as pendency of suit, because suppose a study case has been filed and today it has been transferred. So, here the court has said that the section was held to apply to the transfer, although nothing was done to inform the transferor regarding the institution of the suit, because transferor was completely unaware about it. Transferor was not knowing, that means the seller was not knowing that that this property on this property a suit is going to be filed. Seller is not a good term, but for the purpose of explaining it, it is I am just explaining, because in case of transfer always remember it, that there will be mortgage, there will be lease, there may be the gift, there may be sale. Okay. So, all these things are possible, but I am using the word seller or transferor for your convenience. So, for that purpose, if some transfer is going to be done on the next day, even it will be hit by the pendency of suit. Even the suit has just started a study, it has been filed, that means that there is no total processing has been done, it has been not just it is in the registry, okay, not has reached to the court, only it is in the registry of the court. Even then it will be treated as that now suit is pending and section 52 will apply. Then if a plaint is presented in a wrong court, the transfer take place during such pendency, the doctrine of least pendens would not be applicable. Okay. That means, if plaint has been filed in the wrong court, okay, so it cannot be said that this suit has been instituted. It will be not treated that suit has been instituted. Suit will be instituted only when it will be filed in the proper court. Okay. So, suppose it has been filed in the wrong court 2 months back. Now, when there is a argument on the jurisdiction, it had been found that it is not a proper court. So, those 2 months would be not taken as a this least pendens period, and if transfer had been done during that 2 month time, then 52 will not apply. So, suit or the proceeding must be pending before the competent court. Suit or proceeding must not be collusive. Okay. That means, plaintiff and defendant should not this doing collectively or collusively or acting together in the secret toward the fraudulent or illegal end. Okay. So, sometime may happen that something for the illegal end they are doing this, and it if this is the case, then the suit or this least pendens will not apply. Next is that right to immovable property must be directly in of specifically in question in the suit or proceeding. That means, immovable property must be directly of specifically in question. Okay. That it is first of all matter is related to immovable property, not movable property, and it must be directly of specifically in question. Directly and specifically in question means the property which is the matter of the transfer, okay, that property or matter must be very clear, it should not be vague, and for that purpose only there is a suit. So, the disputed property must be transferred or otherwise dealt with by any party to the dispute. The term transferred in this section includes lease, mortgage, sale, exchange and all. Okay. So, all these things will be included in this. So, specifically this directly of specifically in question is very important, that particular property must be specified, that this particular specified property is in dispute and I am going to transfer. Suppose the whole property is in dispute, okay, and there is a shareholder. Shareholder is going to share that, okay, I am going to sell 1/10th part of this property. Okay. So, 1/10th part of this property, and he is the co-sharer of it, which can be later on during the partition, it may be seen that, okay, what was the portion of it. Suppose there are 4 brothers, so they will get 25%, okay, but he is going to sell only 10%, remaining 25% from wherever it will come, that means balance is 15%. So, it is not a certain property, okay. Property is whole 100% is in dispute, but what is going to be transferred, it not it is ascertained. So, in that case list pendens will not apply. Illustration: a mortgage property, A mortgaged property to B, A mortgaged a property to B, B sued on the mortgage and obtained a decree for foreclosure. Before the decree was made absolute, A sold the property to C. The decree for foreclosure was made absolute and it was held that C was not entitled to redeem. If he had purchased property the suit, he would have been entitled to redeem, though not made a party. But as his purchase was pedentalized, he was bound by the decree. That means, the things that this property was sold during the lis pendens. So, whatever the judgment will come, okay, so C will be bound by it, and it will be not seen that whether the C had notice or not, C did or C purchased bona fidely, or he had purchased without knowledge, with knowledge, it is completely immaterial in this case. Now, next important is fraudulent transfer, that is section 53. Okay. Section 53, and so section 53 talks about the fraudulent transfer and restrict the fraudulent transfer. What it says, that 53, that transfer of an immovable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of creditors so defeated or delayed. So, specifically this fraudulent transfer is a kind of right of the creditors, that if the there is a transfer, fraudulent transfer to defeat the interest of creditors, then section 53 provision of Transfer of Property Act protect the interest of creditor, and it has been specifically drafted for this purpose only, okay, that the interest of creditor must be saved. Otherwise, what will happen, that the creditor will give the credit loan, and once they will ask about their loan, then the person will sell the property to the other person. So, at least the creditor will have right over that property. Okay. So, it has been said that the provision of the subsection shall not affect the right of subsequent transfer in good faith for consideration, and the law for the time being in force relating to insolvency. So, one by one I am going to explain it. Now, come to this. Essential condition is very clear now, that is, first of all, this is the transfer of immovable property. Transfer is fraudulent with intent to defeat and delay the creditors. Okay. Now, whenever you are reading the word transfer, you must be clear that this transfer must be correlated with that what cannot be transferred under section 6. Okay. So, whether that is falling under section 6 or not, so you should be very clear. Okay. So, if it is not given in that list, then it is only transfer under the Transfer of Property Act. So, which can be transferred under Transfer of Property Act. So, there is a transfer of immovable property. Okay. And for what purpose transfer of immovable property? It is for intent to defeat or delay the creditors. There is no other intention has been mentioned under this section. Okay. It is specifically to defeat and delay the creditors. It is not talking about the defeat the other third party or any other transfer. No. Here it is only about the creditors. Okay. Then the above mentioned condition are fulfilled, that transfer of property is voidable by the creditors or creditors whose interest has been defeated, or it is voidable. Okay. Suppose he has transferred the property, but there are others property also on which this creditor will have right. Sometime it may be that whatever the collateral has been given to the creditors, that actually it has been transferred. Okay. So, in that case this will apply. So, saving the interest of the creditor, there is this kind of the provision has been included. Exception of section 53(1), if it is done in good faith for consideration or law relating to insolvency. Okay. Good faith for consideration. Good faith for consideration means what here, that who is going to exception, who is going to use this exception, okay, what it says and for whom it is, who will take the defense of exception. Okay. So, the section 53(1) further provide that nothing in this subsection shall impair the right of a transferee in good faith and for consideration. It means that if the transferee has purchased the property for consideration in good faith from the debtor, then his interest will be protected. Then creditor will have no right in that property. Okay. So, good faith means what? That first of all, this purchaser or transferee had no knowledge about the loan or the involvement of creditor over that property, as well as he had given a proper market value, good consideration for the this transfer, because if the consideration will not be good, then again it will be a kind, it may go under the fraudulent transfer. Okay. So, in that case it has been said, if the this transferee is purchasing the property with a good with consideration and in good faith, that is without notice, then creditor will have no right against that property which has gone to the transferee first. Then it says that 53 also provide that nothing in this subsection shall affect any law for the time being in force relating to insolvency. Okay. This right of transferee is created under the law relating to insolvency, then his right are protected even if the transfer intention was modified. Okay. That means, in insolvency law, if it has been transferred to the transferee even through the bad intention, in that case it will not be fall under this category. Okay. It will fall under the exception of this one. Then next is part performance. Okay. Doctrine of part performance, and the last topic of the discussion of today lecture. It has been added in 1929. So, it was not in the original text of Transfer of Property Act. What it says? The name itself suggests part performance. That means, something has been performed and something has been left. Okay. So, what is actually this and how it has been incorporated, because there is a long story of incorporation of part performance doctrine under the Transfer of Property Act. So, 53A incorporates the doctrine of part performance. This section was included in the Transfer of Property Act by amending this in 1929. Before this amendment, there was no enacted law on this subject. So, if there was no enactment of law on this subject, then it was governed by the principle of equity. That is, Anglo-Indian courts used to apply English equitable principle, English equitable doctrine of part performance to Indian cases. To some extent, I will discuss what was the English doctrine of equity of part performance, and then I will go through some case laws, and then what is now 53A, and ultimately I will discuss the difference between English doctrine of equity of part performance and Indian, that is 53A. So, first of all, what is the doctrine of equity of part performance which is prevalent in England? So, it is called English equity of part performance. So, this doctrine was firmly established in the case of Madison versus Alderson 1883, in which the Lord Selborne observed what he has observed. He said that in a suit founded on part performance, the defendant is really charged upon the equities resulting from act done in execution of contract and not upon the contract itself. If such equities were excluded, the injustice of a kind which statute cannot be thought to have had in contemplation would follow. So, you should always be knowledge about the doctrine of equity as well as law itself, because sometime it has been asked that what is the difference between law and equity, and what is the difference between law of equity and common law. Okay. So, all maximum provision of Transfer of Property Act is based on the doctrine of equity. That means, the law which was at that time prevalent in England was not sufficient in the sense that in some situation it was unable to do the justice. So, for that purpose the equity court came forward and developed certain principle on the basis of justice and good conscience. So, it has been said that that means there may be certain law, but that law is not going to give the full justice about the situation, about the problem, in that particular problem. In that sense, the equity could develop these kinds of the principle. So, in same way, this part performance developed through the law of equity. That means, law of contract is there, and law of contract says that when the contract will be completed, then only transferee will have right over the property. But problem may be that there is a contract for sale, but sale has not happened yet. There may be the contract for mortgage, but mortgage had not done. So, in that case, question here is that means what will happen if there is a contract for transfer, contract for something, and this plaintiff or the transferee is acting or acted or willing to acting. Okay. In all this case, whether the transferee is willing to act or actually acting or acted. So, in that case, what the remedy left with the transferee. Okay. So, for that purpose, because some part has been already performed by the one member. So, what is the duty of the other party? So, this part performance talks about that duty, that if something has happened, okay, something has been done, some part has been performed, then what kind of the rights and duty arises in that transaction. So, for going through this kind of the circumstances, the court has derived this principle of part performance. Okay. So, doctrine of part performance in section 53A of the Transfer of Property Act and English law. First of all, not an application of English equity in toto in India. That means, there is certain modification in English equity law and then it has been incorporated. The law contained in section 53A of the Act is almost the same as it was laid down by the Privy Council in 1914. 1914, that means prior to 1929, okay, when it was added actually in TPA. So, in this is the very leading case, that Muhammad Musa versus Agur Kumar Ganguly. So, in this case, court has said that the case which had applied the English equity of part performance which with certain restriction. In this case, the Privy Council applied the principle by passing the Registration Act. What was happened in this case actually, that there was a Rajinama, okay, that means the compromise. So, there was a compromise between the party and this compromise was unregistered compromise. Okay. So, through that the property was transferred. So, it was unregistered one. So, matter went before the court whether this unregistered compromise can transfer the immovable property, whereas in Indian Registration Act rule was that immovable property above the 100 rupees cannot be transferred without registration. Okay. But here only on the compromise, unregistered compromise, it has been transferred. So, on the basis of that, it has been said that this under the Muhammad Musa case, the Privy Council bypassed the Registration Act by bypassing the Registration Act, and on the basis of oral agreement for the transfer of immovable property was validated. Later on, Privy Council realized it also. Okay. So, corrected his own mistake in RU versus Jadunath case in 1931, and held that the part performance could not be applied in India to override the Registration Act. Okay. So, part performance cannot override the Registration Act, and registration is necessary in that case if property is going to be transferred. So, because this case came later on after inclusion of 53A, but the matter was in dispute prior to that. So, this case is based on the principle of equity, not on the basis of section 53A. So, doctrine of part performance, again it if you will compare with the English law, then it says that there is a two restriction, they are different in two respects. How they are different in two respects? First, in England, equity protects the interest also such a defendant who has taken possession on the basis of oral agreement, whereas in case of 53A, oral agreement is not a necessary this is prohibited. Actually, only written agreement is valid under 53A. That means, through oral agreement there cannot be a part performance, whereas in case of doctrine of English equity part or performance, oral agreement is also valid agreement. Then in England, secondly in England, the equity gives also right of action against the evictor, but in section 53A gives no such right. Eviction right cannot be claimed. Okay. Eviction right cannot be claimed in India, but in England eviction right may be claimed on the basis of part performance. Okay. So, in the case of tenancy tenant, it will apply in England, but in case of tenant in India, it will not apply. Okay. So, first of all, oral agreement will not work in India, in UK it will work. Second, for eviction it will not work in India, but in UK it will work. Then accordingly, it has rightly been said that section 53A, a partial importation into the India of English equitable doctrine of part performance, completely it has not been adopted in India. Okay. Then essential conditions. Okay. So, first of all, contract to transfer an immovable property for consideration. What are the essential criteria? First of all, there must be a written contract to transfer the property, and this transfer is according to section 6. Okay. That means, which cannot be transferred will not fall under this category, plus all kind of transfer, all transfer provided under Transfer of Property Act. So, it is important. So, this transfer will include all contract written only to excluding section 6 conditions, and all kinds of transfer, mortgage, sale, lease, gift, everything, and it must be immovable property, okay, which will fall which used to fall under immovable property definition for consideration. So, there are 4 essential within the first essential itself, that there must be written contract where the immovable property is going to be transferred, okay, for proper consideration. Okay. So, all these things is required first of all. Then second important part is contract in writing and ascertainable with reasonable certainty. So, first of all it must be writing, in writing, contract must be in writing, I have already given you, and ascertainable with reasonable certainty. What is ascertainable with reasonable certainty is important here. Okay. So, example has been given here, a letter written by a owner of the property admitting that he had agreed to sell his half share of the property was not taken by the Supreme Court as deemed agreement to sell so as to meet the requirement of this section. That means, if he is selling the half of the property, it cannot be said that ascertainable with reasonable certainty. The necessary term for constituting a transfer with reasonable certainty could not be ascertained from such letters. So, the wording of your this agreement is very important. That means, property must be identified, portion must be identified. Okay. It should not be vague, it can be identified easily. Okay, this property is going to be transferred. Okay. So, from this party to that party, okay, what rights is going to be transferred. So, everything must be clear. If it is a vague, then part performance will not apply. So, the court had said, after going through the wording of letter, that if this is the language of the letter where the property cannot be ascertained, party cannot be ascertained, okay, amount cannot be ascertained, in that case part performance will not apply, second essential will not meet. Third is about the part performance of contract by transferee, transfer of possession and continuance in possession. That is also very important. Part performance. Okay. Part performance is what? This for what purpose the agreement has been done. Something positive has been done for that. Okay. That means, only making an agreement is not sufficient. Making an agreement for sale, making an agreement for lease is not sufficient. Okay. First of all, agreement must be written, that is true. Without written agreement, nothing is going to be happen. But whether the making a written agreement itself will be treated as part performance? No. After that agreement, something has been done with regard to that agreement. Suppose transferor is going to make a lease of his property, and the transferee is ready to take that lease. Okay. But he has not paid the consideration. He has not paid the consideration, but he, according to the term of agreement, he will pay in 1 month or 2 months. Within that, he took the possession of the lease property. So, taking the possession of lease property itself is a kind of positive action. Okay. Or if he is in that property and continuing with that, even this continuation is also a kind of positive act. So, here it has been said that a transferee has not taken possession of property, this section will not be applicable. That means, the property must be within the possession of the transferee. It is also a sine qua non condition. That is, without that condition, this section will not survive. Okay. So, possession must be under the transferee. Then second is, if the transferee has not taken possession, but has subsequently lost it, okay, this fact will not deprive him of his right under section 53A. If the transferee has if the transferee has once taken possession, okay, once taken possession and later on, that means the transaction is not completed. Prior to that, now he is not in possession of that property due to certain reason, whatever is the reason. Okay. So, it cannot be said that nothing part has been performed. Part has been performed, he was under the possession of, he was already taken the possession of that property, and then after moved away from that, this principle will apply. So, it says this fact will not deprive him of the right of under section 53A. That means, he will have a right to claim part performance, and he can use this section 53A against the transferor, that part has been performed by me, by me, now it is your duty to complete the whole transaction. Okay. So, in that way it works. So, these three next condition is readiness or willingness of transferee. This is also important condition, readiness or willingness of transferee. That means transferee once transferee want to use this section 53A part performance, certainly he must be willing to continue with that position. He must be must be willing to complete this transaction. Okay. So, willingness of this transferee is very important. So, there is a very good saying in law of equity that he who seeks equity must do equity. Okay. So, first of all he is asking the principle of equity of part performance. So, what is expected from him, he must do that. So, what is expected from him? The first of all expectation of is that he will do the part performance. If he is not doing the part performance, then he cannot ask this section 53A. General contract or general other provision of TPA will apply for fulfillment of it. But if he want to apply section 53A, in that case he will have to perform, he must be holding the possession of the property, he is willing to fulfill the term rest of the term of the condition of the contract, then only he can ask for the part performance. Therefore, the transferee who wants to take the benefit of this section must also do his part of the contract. He must be willing and ready to perform his part under the contract. It is not necessary that the transferee must plead his willingness in each and every case. It is not necessary. It can also be inferred from his conduct. For example, here it has been given that where a purchaser of a land has to pay the price after inspecting the revenue records, but he could not do so because the records were incorrect, he could not be said to be unwilling to pay the balance price. Okay. It cannot be, because he has taken positive step. He went to the office, he has verified the records of revenue, and then he found that there is some error in that record. So, he will not pay it. So, that means due to the error in the record, he is not paying the amount, will be not treated that he is unwilling to perform. If that record would have incorrect, certainly he would have purchased that property. So, this will not fall under the category of unwillingness, it will be treated as willingness in a way that he was willing, so that he has verified it, but due to the incorrect records he is not paying the rest of the amount, he is not satisfying the rest of the term and condition. So, same type of the things happen in the Jacob Private Limited versus Thomas Jacob in AIR 95 Kerala High Court, held that where the Wendy company expresses its willingness to pay the amount provided the plaintiff clears his income tax arrear, there is no complete willingness and it is not sufficient for the protection of section 53A. That means, what the condition has been put, the plaintiff clear his income tax arrear. Okay. There is no complete willingness and it is not sufficient for the protection of section 53, because whether income tax arrears willingness to this of the plaintiff is not the business of here of the defendant. Whatever the income tax of the transferor is, it is not. He can only say that whatever the property is going to be transferred, there should not be any tax remain over that. But whether he had paid income tax or not, to what extent, that is not the business of the transferee. So, this kind of the condition will fall under the unwillingness. That means, if it is unwillingness, then 53A will not apply. Okay. Then next point is that this not applicable in tenant in possession, but applicable in change of relationship. This is also very important, that 53A in India is not applicable in case of tenants. Okay. 53A of Indian Transfer of Property Act is not applicable in case of tenant. Earlier I have already told you, because in Britain it has been allowed under the doctrine of English equity of part performance, but India it is not allowed. Tenant has no right to seek protection of his possession by virtue of section 53A when the jural relation is of the landlord and tenant. It is very clear, because in Rent Control Act it has been said that he cannot take defense of this part performance. Why? Because if the tenancy is tenant is there, and he will say I am performing, I am continuing the possession. Okay. So, in that case this kind of defense has not been given to the tenant. But suppose the same tenant is going to become the purchaser of the same property where he is residing. Okay. So, then what will happen? His relationship has been changed from tenant to he has become the transferee. He is going to purchase it. So, thus that relationship has been changed, and now he is under the possession of the same property, because he has now done already the sale of this contract for sale. So, contract for sale has been executed. In next 3 to 4 months he is going to purchase it. So, from tenant, so he has become purchaser, and now the property in his possession. So, if contract for sale has been done and now he is in possession, then the same tenant, now whose nature has been changed, can claim 53A part performance part. Okay. So, it has been said that it is not applicable in case of tenant possession, but it is applicable in case of change of relationship. However, if the tenant become the purchaser, then 53 will apply. Exception to this rule is that the provision to the section contains an exception in favor of transferee for consideration who has no notice of the contract or part performance thereof. Okay. So, exception what it says, that in case of part performance, that the transferee who is purchasing the property with consideration who has no notice of the contract or part performance thereof, then his interest will be saved. How it may happen? It may happen in that way, that again there will be three kind of three party agreement, A, B and C, property is X. Okay. So, if A is selling this property to B, A is selling this property to B, and this B is under the part performance, B is performing, B has done the part performance. Okay. Now, A has sold property to C. When this contract was alive, that means C1, he did contract C2, that X is going to be transferred to C. So, what will happen in this case? That B is the part performer, C is purchasing with consideration without notice of this part performance. Without notice of this part performance, then it is C is exception to this rule. B cannot impose part performance against C. B cannot impose part performance against C. Then second is any right which is transferee may have against the transferor. Any right which the transferee may have against the transferor under this section would not be of any avail against the bona fide transferee for value no notice of the transaction. Okay. So, in that case, this right of the transferee against the transferor, right of the transferee here against the transferor under this section would not be avail against the bona fide transferee. He is the bona fide transferee for the for value, bona fide transferee for value, having no notice of that transaction. Then again C will be not responsible for any right of B against A over this property. Okay. So, right or the part performance both will be not applicable on the bona fide purchaser under this case. Then instrument of transfer. Okay. Instrument of transfer. So, unregistered instrument, it has been this section comes into effect even if the instrument of transfer has not been completed in the manner prescribed therefore by the law for the time being in force, like Registration Act. So, instrument is properly completed according to the Registration Act is not necessary that it must be signed. Okay. Necessary that the instrument of transfer must be signed like document of transfer, that is sufficient. Nature of transferee right under section 53A. Okay. Nature of transferee rights under section 53A. What is the nature of transferee right? Transferee right under section 53A, that if he is performing according to the part performance agreement or sale of this agreement of the sale or transfer, then he can impose all his rights against the transferor. No title or interest in property. No title and interest in property. It says that because it is a kind of only no title or interest in the property, because it is only a part performance. So, he can claim that it must be completed. Okay. Transferee may complain that it must be completed, I have done this part. So, now transferor should do rest of the things, but right he cannot claim on the property. Any kind of the right or title will not be created unless the transaction is going to be completed from the side of the transferor. Okay. So, it is only the right to claim to complete the transfer and always to protect the possession also. No right of action, only for defending possession. Okay. So, no right of, because there is no such kind of the right or title over the property. So, he cannot claim any kind of right of the action, but yes, when the transferor will evict him, transferor is going to say that okay, go from the out of the property. In that case, he can say I have performed part, I have a right over this, I will continue with this possession, you will have to do all these things, which is rest for the completion of the contract. So, this section confers on the transferee a right to defend his possession, whether as a defendant or as a plaintiff, it is not relevant. Okay. Whether this is a defense from the plaintiff side or defendant side, it is irrelevant, it can be used by the both the party. So, last is difference between English law and Indian law. What is the difference between English equity part performance and Indian 53A? So, first is the oral agreement is sufficient in UK, in English law, must be in writing in Indian law, then it can be used as sword and shield in English law. Okay. But where it is in Indian law, it can be used as a defense only, as a shield only. In English law, it is still a part performance is a equity under equity, whereas now in India it is a part of the statutory right. Okay. So, in that way we have seen or we have studied about the lis pendens, then fraudulent transfer, and ultimately we have seen about the part performance. So, it is all about these three concepts. So, we will meet in the next lecture. Thank you so much. Thank you all.